Hi, my name is Jasmine Beaker, and my project is on trademark law. What is a trademark? Any word, symbol, or phrase used to identify a particular manufacturer or seller's products and distinguish them from another. So, any kind of a picture or a name that will set one company apart from another, that's what a trademark is. Some of the more famous trademarks are listed here in this picture. You can see Coca-Cola, Apple, Google, Nike, the big name brands. What all is included in a trademark? So other than protection of words, symbols, and phrases, trademarks can also include other aspects such as color or packaging. This falls under a category known as trade dress. Two examples of trade dress would be the Coca-Cola packaging on their bottles and the magenta color that T-Mobile has. Both of these are trademarked. Why are trademarks useful? Trademarks provide ease of identification for products, which means it makes it easier for a customer to identify what they're looking for. They also give an incentive to companies to increase their quality output. Because when a customer knows what they're looking for, the quality is going to be even higher. Who controls trademarks? Trademarks are governed both at the federal level and at the state level. Most of the governing now, however, is done at the federal level. What do I need to make a trademark? In order to form a trademark, the mark in question must have intention to be used in commerce, and it must also be distinctive. There are 4 categories for trademarks, constituting different levels of protection. They are arbitrary or fanciful trademarks, suggestive trademarks, descriptive trademarks, and generic trademarks. Arbitrary and fanciful trademarks. These trademarks have no logical relationship to the product. However, they are inherently distinctive and they warrant a high level of protection. Some examples would be Apple, Exxon, Kodak, and the Nike swoosh. Suggestive trademarks. These marks evoke or suggest a characteristic of the good. They are inherently distinctive and they warrant a high level of protection. An example of this would be Coppertone. Coppertone does not have a trademark that is directly related to their product, but it does suggest that they are a tanning lotion, and that is why it is a suggestive trademark. Descriptive trademarks. These marks are when the public starts to associate the mark with a particular producer in the industry rather than the product itself. An example of this would be Holiday Inn, because consumers have started to associate hotels with the name brand Holiday Inn rather than with the hotel industry itself. Generic trademarks. This describes a general category of a product. It is not given any protection because it is not an actual trademark, it is just a generic name. An example of this would be like computer. How do you get trademark rights? There are 2 ways to gain the rights to a trademark. You can either be the first to use the mark in commerce, or you can be the first to register the mark with the U.S. Patent and Trademark Office, the PTO. Protection on the mark starts to kick in after secondary meaning has been reached. Priority is limited to the specific geographic area that you are in, unless you register with the PTO, because the PTO lets you use the mark nationwide. However, if there is somebody elsewhere in the nation that has prior usage of the mark that you are trying to register, they get to retain the mark. So if I decided I wanted to register a pizza company by the name of Brooklyn Pizza, and I register it with the PTO, and I find out that there is a company in New York that calls themselves Brooklyn Pizza, they get to retain their name. So what does it mean to register a mark? When you register a mark through the PTO, there are several benefits that are associated with it. You get to have nationwide use of your mark. You also get to have nationwide constructive notice to others that the trademark is owned. You can bring your infringement suits to federal court. You could potentially recover damages, attorney's fees, and other remedies. And after 5 years, the mark can become incontestable, which means that nobody could try to challenge you for the name. Can you ever lose your trademark rights? Yes. You can lose your trademark rights through abandonment, improper licensing, or genericity. Some examples of marks that lost their rights due to genericity are aspirin, cellophane, and thermos. These products have lost their trademark rights because they have become very generalized. They aren't actually related with one company or another anymore by the public. They're very general. What is trademark infringement? Trademark infringement is use by another of the same or a similar mark that violates the prior trademark rights of another in the jurisdiction where such use occurs. What constitutes infringement? Likelihood of confusion is what constitutes infringement. This means how likely is a person in the public to confuse one mark with another. And when a court is determining the likelihood of confusion, they look at the strength of the mark, the proximity of the goods, how close they are to each other, similarity of marks, evidence of any actual confusion, similarity of marketing channels used, degree of caution used by the typical purchaser, and the defendant's intent. What is trademark dilution? Trademark dilution is a trademark law concept giving the owner of a famous trademark standing to forbid others from using that mark in a way that would lessen its uniqueness. Under federal law, dilution only applies if a mark is famous. And when a court is determining whether or not a mark has been diluted, they look at the degree of distinctiveness of the mark, the duration and extent of its use, the amount of advertising and publicity that it has, the geographic extent of the market, the channels of trade, the degree of recognition in the trading areas, use of similar marks by third parties, and whether or not the mark is registered. Under state law, however, dilution can apply without a mark being famous. The court just looks at whether or not it has selling power and whether or not the two marks are substantially similar. Once the prerequisites for dilution are met, the owner of the mark can bring an action against any use of the mark that dilutes the distinctive quality of that mark through blurring or tarnishment. Blurring happens when the power of the mark is weakened by its identification with dissimilar goods. Tarnishment happens when the mark is cast in an unflattering light. An example of this is Toys R Us versus Accowie. Toys R Us versus Accowie. This is a successful dilution case won by Toys R Us against a pornography site that went by the name of Adults R Us. The defendant ended up having to cancel their domain name, adultsrus.com. This is an example of tarnishment because people were starting to think that Adults R Us is related with Toys R Us because it had such a similar name. Examples of rejected trademarks. Since a trademark has a relatively loose definition, there have been many ridiculous and often humorous attempts at trademarks. This is a rejected trademark of the name Snooki. The Jersey Shore star, Snooki, decided that she wanted to trademark her name, Snooki. She was denied due to a possible confusion with an existing cartoon cat by the name of Snooki. You can see the star pictured, and you can also see the cat pictured. Another rejected trademark is the Walmart smiley face. Walmart wanted to trademark the smiley face that they used in their advertisements. However, since smiley faces are very generic, they were denied because the smiley was ruled to be public domain. There are, however, some things that get trademarked that are rather interesting as well. So here are some examples of approved trademarks. An accepted trademark is the Boise State football turf. Boise State has an iconic blue-colored football field, and they wanted to trademark their color so that nobody else could have a blue turf just like them. Their trademark was approved, and they have their blue turf to this day. Another accepted trademark is Tebowing. The NFL quarterback Tim Tebow trademarked his prayer stance, which has been named as Tebowing. Are trademark laws actually helpful? While trademark laws were originally designed to protect products and their owners, there has been some speculation lately that the laws are antiquated and that they can cause more trouble than they are worth. An example of this would be Facebook being able to trademark the word face. Some question whether or not Facebook should be able to trademark something that comes up so often in everyday life. Another example would be Apple being able to trademark the word apple. A lot of people feel like nobody should be able to own something that really should be a part of public domain. So in conclusion, I have found trademark law to be a very interesting topic since it covers such a wide range of products. And I also believe that trademarks are a necessity, especially in today's world. These are my sources, and I hope you enjoyed my presentation, and I hope that you learned something from it. Thank you.